This lecture is constitutional law. It will cover a simple overview and the Commerce Clause. The Commerce Clause also including the Dormant Commerce Clause. The discussion of constitutional law is not to be fully inclusive. We certainly can't do this in the hour and a half of lectures that we have. The Constitution is probably one of the most regarded documents in history. I regard it as only secondary to the Bible in its significance, and it only grows in significance from decade to decade. We see this with new democracies. For example, in Central and Eastern Europe, the breakaway from the Soviet Union into democracy, there was the United States Constitution being considered there. When U.S. professors go abroad to teach, one of the more requested topics or areas of discussion is U.S. constitutional law. First, we'll start off with a very brief overview of the workings and how it's set up. Article 1 establishes the legislative branch. It tells the Congress what their powers are. It gives them certain enumerated powers, some of which we're going to talk about in this lecture and the next one. Article 2 establishes the executive branch, the powers of the presidency. Note that his powers are limited. Article 3 establishes the judicial branch, the power of the Supreme Court. It requires only one court, as we've noted in an earlier lecture, and that is the United States Supreme Court, but it gives Congress the authority to establish the appellate courts and the trial courts as it deems necessary. Article 4 has two principal provisions, the Full Faith and Credit Clause and the Privileges and Immunities Clause. First, the Full Faith and Credit Clause is an important provision, and it says that all of the states and the federal government generally have to give full faith and credit, meaning they have to recognize decisions of courts of the various states. Without the Full Faith and Credit Clause, the way litigation would work would be this way. A plaintiff would sue a defendant in state court. The defendant would then run away to another state with all of his assets, and without the Full Faith and Credit Clause, the plaintiff would then have to go to the new state of residence, sue them again, and try to collect then. It would be completely unworkable. With a Full Faith and Credit Clause, a plaintiff can take the judgment of one state or an arbitration decision, as far as that goes, and take it to the state where the assets are located or where the defendant has moved, and then execute on it. The Privileges and Immunities Clause is a provision that requires the states and the federal governments not to treat citizens of differing states differently. The Privileges and Immunities Clause has been held to require states that license certain professionals, for example, lawyers, CPAs, so forth, to accept non-residents for licensure. This is the case of Piper versus New Hampshire State Bar, in which the court the Supreme Court of New Hampshire had rules that required any attorneys licensed in the state to be residents of the state. Miss Piper lived across the state line, but she wanted to practice law in New Hampshire, and she was refused a license. The U.S. Supreme Court said that she should have been considered for a license, and it rejected the New Hampshire Supreme Court's argument that residency was required in order to assure that the attorneys in New Hampshire would know New Hampshire law and it would protect the citizens of the state. The Supreme Court said this is too broad of a restriction and that there were other means to assure that the lawyers of the state knew New Hampshire law and could practice there. And one such way would be through continuing education requirements. Article 5 provides for amendment to the Constitution. It's not easy to amend the Constitution, although politicians always argue that they will try to amend the Constitution, for example, school prayer, term limits, and balanced budget. Supermajorities are required in the House and the Senate, and then it requires 2/3 of the states to ratify it. Very difficult. If you look at the amendments over the last nearly 100 years, they have been low-hanging fruit. Article 6 is the Contracts Clause. This article prohibits the federal government from entering laws, executing laws, enacting laws that would effectively invalidate existing contracts. In the Blaisdell case from the 1930s, the Supreme Court did recognize the fact that Congress can affect change in contracts. For example, Congress enacted a moratorium on farm foreclosures. This during the Great Depression because too many banks had foreclosed on farmers. But in holding that this did not violate the Contracts Clause, the court argued that the means were reasonable. One, that there was a compelling interest to do so. Two, it was limited in time, meaning it could only carry on for 5 years or until such need for it is relinquished. And three, it didn't invalidate the contract. The amendments, there are 27 amendments. Don't look for anything soon. One of the amendments was, meaning prohibition, was withdrawn, revoked, later on, or abolished is the better phrase. General arguments that it was unworkable. We talked about that in an earlier discussion. There may not have been a need for it at the federal level. The old 27th Amendment was the Equal Rights Amendment, and it failed, even though it passed in the House and the Senate. It did not get the necessary number of states to ratify it, and then it was replaced, or more recently, an innocuous one dealing with pay raises for Congress. Let's look at why the federal government has grown so much. and the limits on the federal government and the Congress, and for this matter states and local governments as well, to effect constitutional protections through legislative means. There are three tests of scrutiny, i.e. constitutional tests, to determine whether or not a legislative enactment or a governmental act meets constitutional restrictions. It goes from high to low. The highest being strict scrutiny. Then there's a middle one called intermediate scrutiny, or and then rational basis test, which is the least of all of them, easy to meet. First, strict scrutiny. This is the highest level of scrutiny. And when I talk about scrutiny, I'm talking about a court will review the act of the government, usually some legislation or rule, and see how it affects the rights of the individuals. Strict scrutiny is used when an individual's fundamental right is affected by the government. And a fundamental right are rights that are implicit in ordered liberty or rooted in the nation's history or tradition. Recent examples of this is the finding that DOMA, the Defense of Marriage Act, an act of Congress, was held unconstitutional because it violated due process, deprived same-sex married couples of liberty that's allowed or given under the Fifth Amendment. It was odd that same-sex marriage was regarded by a majority, meaning 5 of the Supreme Court justices, as a right based on tradition and history of the nation, when that's certainly not the case. Another example was the recent same-sex marriage case where same-sex marriage was upheld, meaning states had to allow same-sex marriage and had to recognize same-sex marriage. This is the Obergefell versus Hodges case that we mentioned before, and it was upheld under strict scrutiny based on Equal Protection Clause. Now, usually, at least in the past, restrictions on activity or limits on such things as marriage or so forth, because of sexual preference, was not regarded as required under strict scrutiny. It looks as though that's changed. Another situation in which courts will apply strict scrutiny is when persons are treated differently because they are a member of a suspect class. And suspect class is usually because of race or alienage, what country they're from, when they're treated differently from other persons simply because of race or alienage. Note that the court, although they never, in either of those two cases, U.S. versus Windsor or Obergefell versus Hodges, did not argue that strict scrutiny included same-sex couples as a suspect class. They simply argued that the right of marriage and equal protection were fundamental rights. Now note the strength of this test. Strict scrutiny requires the government to have a compelling interest, and the means, meaning the statute or the restriction, must be narrowly tailored and only going so far as necessary to achieve that compelling interest. When I say compelling interest, that means the government needs to act. Not that the government should act, or it would be good for the government to act, but that it is compelling. And the second requirement, that the means must be narrowly tailored, means can you achieve this compelling interest with less restrictive means? Can you get there in some other way without denying the rights? It is hard to meet. It is hard to meet. But I will simply argue that in these two cases involving same-sex marriage, 5 of the justices knew what they wanted, and they bent the constitutional rules to get there. It weakened constitutional arguments. Intermediate scrutiny is of very limited use. It's when the government acts to treat persons differently because of gender or illegitimacy. In the earlier lecture, we talked about the problem of illegitimacy, historically why that was so bad. Gender speaks for itself historically. Historically, under the common law and family laws of the states, women have been treated substantially less well than men, almost like second-class citizens in some regards. For example, it was only about 110 years ago in which the state of Louisiana had property law that allowed a married man to sell his wife's property without her consent. She could not sell her husband's property without his consent, but he could sell her property without her consent. The purpose being that such powers given to the husband promoted domestic tranquility. That was struck down. The intermediate scrutiny test is thus: government must have an important interest. Important, not compelling, not legitimate, important. It's a middle ground. And 2, the statute must be a fair and reasonable means to achieve the interest. The means must be substantially related to the important interest. In fact, intermediate scrutiny at times is also called substantially related test. Now, intermediate scrutiny has been applied in equal protection. You probably have never seen 6-girl basketball from grade school and high school. Well, that's what we had up until the 60s and the 70s, when it changed to 5-girl basketball full court. It was not a very good product on the whole. And Arkansas, the state of Arkansas, was one of the last states to change. In a case in the Court of Appeals of Arkansas, Sullivan versus the Arkansas Interscholastic Athletic Association. It made the rules for grade school and high school athletics, public school athletics. A rule requiring six-girl basketball was challenged on equal protection grounds. Intermediate scrutiny was applied. The question is, did the government have an important interest? The government argued, we have an important interest because girls are more frail than boys. Girls tend to get tireder sooner. When they get tireder, they get more prone to get injured. The more girls can play, 6 is greater than 5. And so they're looking out for the girls. The Arkansas Court of Appeals, in applying intermediate scrutiny, found that the interest was suspect at that, and the means were not a fair and reasonable means. The means were not, meaning the restriction, 6-girl basketball rather than 5-girl basketball, was not a way to achieve the purpose. Keep in mind, Miss Sullivan argued that because she had to play 6-girl basketball, her chances of an athletic scholarship to a college was greatly reduced. A reasonable argument. And the court argued that there were other ways to assure safety of the girls than simply requiring 6-girl basketball. Intermediate scrutiny was also applied in a Second Circuit Court of Appeals case, and a case out of New York, and this is fairly recent, 2012, in Kachowski versus County of Winchester. Ms. Kachowski, a resident of New York, applied for a handgun permit. And under New York gun laws that had been around for 100 years, to get a handgun permit, this is a carry permit, the applicant must show, quote, proper cause, end quote, to obtain a license. And they usually only held that persons with proper cause included persons who actually had a potential physical threat against them. Shopkeepers, persons in security, persons of this nature, rather than an everyday citizen. And so she was denied the handgun permit. Ms. Kachowski was a transgendered person, so one would think that she would have a pretty valid argument regarding the likelihood of injury or molestation because of her status as a transgendered person. The Second Circuit Court of Appeals applied intermediate scrutiny to this case. Now note, the Second Amendment is the right to bear arms. In an earlier case, the U.S. Supreme Court had held that the right to bear arms included the right to have a handgun in the home, but it was not construed to go farther than that. This is the Heller decision. And so the Second Circuit Court of Appeals considered the 100-year history of New York's permit law, and they held that it was a fair and reasonable means. But note that the government had an important interest. They did not apply strict scrutiny requiring a compelling interest. Had they applied strict scrutiny, they probably would not have found against Ms. Kachowski. Third test is the rational basis test. This is the lowest level of scrutiny. Easy for the government to meet. Seldom is it rejected, meaning seldom is there a state or federal law overturned as a result of it. It explains why the federal government's powers have grown so much since the Roosevelt Supreme Court in the early 1930s. The test: the government must have a legitimate interest with a rational basis in acting, and the means must be reasonable. The end, meaning the objective or the purpose, has to be legitimate. There has to be a legitimate need. Very easy to meet. Very easy to meet. Because practically anything is legitimate. Any need of government is legitimate. And the ends must justify the means. They don't have to be, the means do not have to be essential, only appropriate. This is the reasonableness of it. This explains why we have so much federal law and why the government can do so much. You're going to see when we discuss the Commerce Clause how the rational basis test has been applied, and you'll see the breadth of the government. There are several important constitutional provisions affecting business. We won't be able to discuss all of them. They include the Necessary and Proper Clause and the Commerce Clause, which we'll focus more on the Commerce Clause. The Due Process Clause, which we discussed earlier as it pertained to the fairness of large punitive damage awards. Equal Protection Clause, which we've talked a little bit about already. The Takings Clause. This is eminent domain. Also with the Takings Clause, the Just Compensation Clause is part of the eminent domain. The Import-Export Clause. And then the First Amendment. The First Amendment will principally focus on speech. The rights of the criminally accused. We will not discuss these other than in passing the Fourth, Fifth, and Sixth Amendments. Fourth Amendment, the freedom against unreasonable searches and seizures. This comes into privacy rights. The Fifth Amendment, freedom against self-incrimination. Due process requirements as well. And the Sixth Amendment's right to a speedy trial, right to a jury trial. All right, let's begin with the delegation, the delegated powers, and the Necessary and Proper Clause. Here we're focusing principally on business. Article 1, Section 8 says that Congress shall have the power to make all laws which shall be necessary and proper for carrying into execution the foregoing enumerated powers. And these foregoing enumerated powers, we'll talk about in just a second as to what they are, and all of the other powers vested by this Constitution in the government of the United States or in any department or officer thereof. These necessary and the enumerated powers: interstate commerce, trade with foreign nations, taxing, spending, provide for the military, provide for the national defense. Very limited enumerated powers, not specifically in the area for providing social justice, etc. Here, the constitutional requirement in order for the government to act usually, unless you're treating people differently because of race or alienage, or unless you're affecting traditional fundamental rights, which is seldom in this area, or unless you're treating people differently because of gender, all of those being exceptions requiring strict scrutiny or intermediate scrutiny, the constitutional requirement is the rational basis test. Extremely broad in application. The Commerce Clause. Now, this is the national powers of the Congress. Article 1, Section 8 says that Congress shall have the power to, quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes, end quote. This is the broadest power of the Congress. The modern view is that Congress can regulate any activity which affects, underscore affects, interstate commerce, meaning that there is a substantial economic effect on more than one state. In the case of the National Labor Relations Board versus Jones and Laughlin Steel in 1937, the U.S. Supreme Court had to construe whether or not Congress had the authority through the Fair Labor Standards Act to establish a federal minimum wage. Jones and Laughlin Steel did not pay the federal minimum wage. They were prosecuted by the National Labor Relations Board. Jones and Laughlin Steel argued that the Congress had no authority to tell it or to require it to pay a minimum wage, that it had operations only in one state. The U.S. Supreme Court upheld the national minimum wage, saying that the Congress can regulate any activity which affects interstate commerce, meaning that there's a substantial economic effect on more than one state. The rationale is that if Jones and Laughlin Steel did not pay the federal minimum wage, it would have a competitive advantage on those companies that did pay the federal minimum wage, and therefore the non-payment of the federal minimum wage would have a substantial effect on interstate commerce. Note the broadness of it. All right, what about minimal activities that are personal in nature? In the case of Wickard versus Filburn, a 1942 Supreme Court case, Filburn is being prosecuted by the federal government. Here, Wickard, the Secretary of Agriculture. This Wickard is also the father of my old law school advisor at the University of Tennessee. Filburn was participating in a crop subsidy program, the payment of monies by the federal government to farmers not to grow. These are crop supports. And it was a way of reducing the supply of farm commodities and therefore stabilizing the price. Well, Filburn was growing some crops that he was paid not to grow, but he was growing those crops for use on the family farm, not for selling. They were for consumption on his farm. It was a personal activity, and he was prosecuted for it. Filburn argued that the Congress had no power to tell him what he could grow for personal use. This was a private activity. The Commerce Clause dealt with commerce. His private activity was not interstate commerce. And it was a small amount. The Supreme Court held for the government, however, in the prosecution, and it said even though the activity is minimal by itself or strictly personal in nature, Congress may regulate the activity if it, when combined with others doing the same activity, meaning all of the farmers doing the same thing, growing these crops for their personal use, would have had a cumulative effect on interstate commerce. And if all the farmers who received the crop supports had grown for their own personal consumption, it would have affected interstate commerce because they wouldn't be buying the grain for their animals, and therefore it would affect supply and demand. The rational basis test was applied in both of these. It was the Wickard versus Filburn case that was supposed to be the basis for the decision in the Affordable Care Act case, the individual mandate case, i.e. the Obamacare case, from just a few years ago, because the argument there was that the decision to participate in a market was, meaning to buy the insurance, was a personal activity, minimal in itself, intrastate, and that the question is whether or not the court would stretch the Commerce Clause to uphold the individual mandate. Well, the reality of it is a majority of the court, including John Roberts, held, and this was the conservative wing, held that the Commerce Clause did not require an individual to participate in the market. They would not stretch Wickard versus Filburn that far. It should be noted that the 4 liberal judges in dissenting opinions said that they believed the Commerce Clause would support the individual mandate, meaning they would stretch Wickard versus Filburn that far. It's dangerous to think about what could be happening. Now, in Sebelius versus National Federation of Independent Businesses, the majority, in an opinion by Chief Justice John Roberts, held that the taxation clause, the taxing clause of the Constitution, supported the individual mandate, meaning Congress has the power to levy taxes, and they said this was a tax, that it was not penal in nature, that it was collected by the Internal Revenue Service, and that the amount of the tax, if you will, the penalty as the tax, was not more than insurance, and therefore it met the taxation clause, and therefore they upheld the individual mandate. Now, in my opinion, by using the taxing clause, even with the President and the Congress, to the man saying this was a penalty and it was not a tax, they substantially damaged the Constitution because it gave a blueprint for Congress to control anything it wanted to simply by calling a penalty a tax. The Commerce Clause has been used to regulate business and non-business related activities in a number of ways. In essence, the courts through the decades have stretched the Commerce Clause because the rational basis test has been applied. The Commerce Clause has been used to uphold anti-discrimination laws. In Heart of Atlanta Motel and Katzenbach versus McClung, two 1964 test cases in the United States Supreme Court. The Civil Rights Act of 1964 was upheld under the Commerce Clause. Now, in my opinion, the Civil Rights Act of 1964 was probably the greatest piece of federal legislation since the 13th and 14th Amendments. Absolutely necessary. The only group of laws that I would put above that probably are the environmental laws, without a lunatic environmental protection agency, of course, because without the environmental laws, perhaps we're all dead, or our quality of life would be such that we wouldn't recognize it as it is today. The Heart of Atlanta Motel case, in which the U.S. Supreme Court applied the Commerce Clause and stretched it. Heart of Atlanta Motel owned a motel. They advertised outside of Georgia. The hotel was located in Atlanta, Georgia. They sought travelers coming from the Midwest and the Northeast, traveling on the interstate on their way to Florida on vacation. The hope was that they would stay at the Heart of Atlanta Motel in Atlanta, Georgia. If you were white, you could stay there. If you were black, you could not. This is not anything abnormal for the early 1960s. Happened all the time. Probably was more apt to happen than not apt to happen in the South. This is because of segregation. Heart of Atlanta Motel being prosecuted now by the federal government under the Civil Rights Act, the public accommodations provision that prohibited persons providing public accommodations, as in this case, hotel, that they could not discriminate because of race or religion or color or national origin or sex meaning gender. The Heart of Atlanta Motel, as the defendant argued, you can't tell me who I have to serve. I don't have any operations outside of Atlanta, Georgia. All I do is advertise out. I am an intrastate activity. And the court held, again, that this intrastate activity that substantially affects interstate commerce could be regulated by the Congress. Even farther stretching, their argument was the activities of the Heart of Atlanta Motel substantially affect interstate commerce because if black people felt that they could not get accommodations, hotel accommodations when they traveled, they wouldn't travel. And if they didn't travel, they wouldn't spend their money on gasoline, on other hotels, on restaurants, on tourist attractions and so forth, and that the discrimination would substantially affect interstate commerce. In Katzenbach versus McClung, this is a case involving Little Ollie's Trolley Barbecue in Birmingham, Alabama. Ollie's Trolley Barbecue, a barbecue stand, restaurant. They didn't do anything outside of Birmingham, Alabama. No advertising, no no other businesses and so forth. They strictly were local. If you were white, you could go inside, sit down and eat. If you were black, you could order your food at a side counter, at a side window, and you could eat outside. There was discrimination because of race. They were prosecuted under the Civil Rights Act of 1964, and the United States Supreme Court upheld the prosecution, even though Ollie's Trolley Barbecue argued that the activity was purely personal and Congress had no authority to regulate purely personal and intrastate, or it's not personal, but intrastate activity. They couldn't regulate purely intrastate activity. And the Supreme Court, again, upheld the Civil Rights Act public accommodations provision to apply to purely intrastate activity, because there would be a substantial effect on interstate commerce. If black people could not go inside a restaurant to eat, then they would not go out to eat, and the meat that Ollie's Trolley Barbecue purchased for their products could not. This meat came from outside of the state of Alabama, say the Midwest, at the meat packers there, and therefore, if Ollie's Trolley Barbecue would not sell to black people, then this meat would not be purchased from the providers in the Midwestern states. The tomatoes that would be grown in outside of Alabama, for example, California, Florida, or Texas, would not be acquired. Same for the lettuce and so forth. You see the stretching. In criminal laws, the Commerce Clause has been applied. The Mann Act, which makes it a felony to carry a woman across state lines for illicit purposes, this being the white slave trade criminal provision, it was upheld. So how far can you go with the Commerce Clause? This is extraordinary power. Well, it wasn't until 1995, when there had been a shift in the Supreme Court from a liberal bent, and that liberal bent went from the 1930s up to the early 1990s. In the case of U.S. versus Lopez, this was a case involving federal handgun laws, federal law that made it a felony to possess a gun, a handgun, a gun, at a school. The state laws have similar. The state legislatures have adopted similar laws, but this is federal prosecution, and Lopez was being prosecuted by the federal government because he had this gun, and his defense was that the gun law for which he was being prosecuted was unconstitutional. There was nothing to support it. That the Commerce Clause would not support this. It was not within this particular criminal provision. It was a state matter. It was not within the Congress's purview. Now, he was convicted, and it was upheld by the United States Supreme Court in a 5-4 decision where the conservatives on the court struck down the federal prohibition of carrying a gun on school property. The reasoning is they applied the rational basis test, the lowest level of scrutiny. The government argued that it had a legitimate interest, and that legitimate interest was to provide education to children. The government argued that without this, if there was a fear of violence against the children because of handguns, then the children would not go to school. And if they didn't go to school, they wouldn't study. And if they didn't study, they wouldn't graduate, and they would be subject to, or the federal government would then have to pay subsidies and benefits and welfare to them. It was a good argument on the whole. But the court accepted the legitimate interest, but they found the means, meaning the criminal prosecution, to be unreasonable. There are other ways to assure good education of children than this criminal means. And so they struck it down. So effectively what a conservative court did, it limits the power of Congress. In 2000, in U.S. versus Morrison, the Supreme Court, citing Lopez, and again applying this requirement that the means must be rational, reasonable, struck down a provision in the Violence Against Women Act in which the victim, female victim of a molestation, could sue a university where she was molested. In this particular case, Miss Morrison was on the campus of Virginia Tech. She was molested there by a perpetrator. What's she going to get by suing the perpetrator? Nothing. So she sues the university under the Violence Against Women Act because they didn't do enough to protect her. Now, this would typically be state law, tort law, premises liability law, not federal law. But this is a federal right to sue. And the Supreme Court struck down the provision saying, even though recognizing that there was a legitimate interest in protecting women against violence, the right to sue was not substantially related to that legitimate interest. We talked about Sebelius versus the National Federation of Independent Business a while ago. Now let's look at this from the state's perspective. Can the state regulate interstate commerce? The answer is yes, they can. And they commonly do. They commonly find a legitimate interest in doing so because of health, safety, conservation, moral concerns, etc. All right? It works with the 10th Amendment. This is called the Dormant Commerce Clause. D-O-R-M-A-N-T, Dormant Commerce Clause. Works with the 10th Amendment, the reserved powers by the state, when the federal government has not regulated or probably would not regulate an activity. You cannot, a state or local government cannot take the powers away from the federal government. They cannot act in any way derogatory to the federal legislation because of the supremacy clause, or what's called preemption, right? Which means federal law is supreme over state law. So if the federal government has already legislated in an area, you can't contradict it. If the federal government has said it wants to be the only regulator in an area, then the states have no power to regulate. For example, food and drug regulation, nuclear power regulation. Congress or the states have no authority at all to regulate in that area. Environmental, for example. States regulate environmental concerns all the time. The federal government has not announced that it wants to be the exclusive regulator. It's just that the states cannot interfere with the federal legislation. For example, California has the most restrictive laws on the environment in the country. They're not preventing the federal government from acting. It simply is, if you're in the state of California, they will regulate more harshly. And sometimes they also do the same thing for consumer protection. The requirements for states to regulate commerce requires the courts to do a balancing of interests by the states, recognizing that the states have interests to protect. All right? So the courts balance the federal interest against the state interest. The test for to determine whether or not a state is acting within the Dormant Commerce Clause, such that the state regulation of interstate commerce will be upheld as constitutional, is that the state may not impose a direct burden on interstate commerce. Never can. The state cannot impose a direct burden on interstate commerce, but it may impose an indirect burden on interstate commerce as long as it is not an unreasonable burden. An indirect burden as long as it is not an unreasonable burden on interstate commerce. That is the test. All right, let's just work through some of this. Examples of the state regulating commerce. Let's take some old cases. For example, if we go back to 1938 to South Carolina State Highway Department versus Barnwell, a South Carolina law prohibiting the use on the state highways, South Carolina highways, of motor trucks and semi-trailer trucks whose width exceeded 90 inches and whose weight included a load of 20,000 pounds. Now, keep in mind, this is from the 1930s. We don't have the same vehicles as we have now, but at that point in time, the roads were not as good. There was no interstate system, and so we had lower limits. Well, in this particular case, the shippers, the defendants, had trucks larger than that. And so they challenged the state regulation on the 90 inches in width and the 20,000 pounds of weight. And the Supreme Court held that in the absence of congressional legislation, the judicial functions under both the Commerce Clause and the 14th Amendment stop with the inquiry as to whether the state statute which affects interstate commerce is with the province of the state legislature, and whether the means of regulation chosen are reasonably adapted to the ends sought. Here, the Congress had not already preempted the field. So the states had the power to regulate the transportation within the state, even though such regulations may have some effect on interstate commerce. It didn't discriminate. Right? The Dormant Commerce Clause requires that states do not discriminate. In this particular case, it was all trucks, not just South Carolina, not just state trucks outside of South Carolina. And so in this particular case, there was no finding of a burden that would strike down a non-discriminatory statute. In this particular case, the rational basis test was applied. In another case, a 1945 case, Southern Pacific Company versus Arizona, the Supreme Court had to decide on whether or not the Arizona train limit law, which made it unlawful to operate a train within the state if the train had more than 14 passenger cars or 70 freight cars, whether or not that was a burden, an unreasonable burden on interstate commerce. Now keep in mind, with California or other adjacent states not having this low train car limit, that in essence a longer train coming from California would have to stop at the border, take off some cars, proceed through the state, and then they could add the cars on again. So it was challenged. The issue is in determining whether a state law imposes an unreasonable burden on interstate commerce, is it for the courts to balance the burden to be imposed against the merits and purposes to be derived from the law? The court held that there was a wide scope left to the states in regulating matters of local concern, but that the regulation must not materially restrict the free flow of interstate commerce or interfere with it in matters requiring national uniformity. It balances the interest. All right. As I said, the state or local government must not discriminate against interstate commerce, meaning you can't discriminate against non-residents. And this is typically in the case of licensure, permits, or taxation. This ends this first part of the constitutional law, and the next lecture will pick up on other constitutional provisions.